If you're interested in information about selling a cannabis business, we have a free report which you can download by using the QR code that's on the screen right now. It's entitled Everything You Need to Know About Selling Your Cannabis Licensed Business. Again, you can get that report by using the QR code on the screen. My name is Barton Morris. I'm the principal attorney at the Cannabis Legal Group. Today I'm going to talk about due diligence in a purchase or sale of a marijuana-related business. This is the second part of the mergers and acquisitions presentations or a set of videos that I will be delivering. The first part was about deal structuring. Now the second part is about doing the appropriate due diligence. That deal structuring was just to be a reminder, was about whether it's going to be an asset sale or a membership interest purchase, or like a shareholder purchase. The difference being that the asset sale, the buyer is coming in buying only the assets, not the actual company or the entity, whereas somebody coming in buying a membership interest actually buys the company. And that company remains, and that license remains in that company's name. This is important when it comes to due diligence. Now, due diligence is the procedure through which a buyer will perform the investigatory work or the investigation necessary to ensure that they are actually buying what they're intending on buying. It's a normal and regular part of any deal. It's very common in residential real estate transactions, for instance. Like in residential real estate, usually a buyer has the opportunity to perform like a home inspection or title inspection, or they want to look and make sure that they qualify for a mortgage. Those are the same types of considerations, just more so for the buying and selling of a business. There are many different considerations and different aspects of due diligence that have to be taken into consideration when buying a marijuana-related business. First of all, as I had said about the fact that we have to determine whether there's an asset sale or a purchase of the membership interest. When a buyer is purchasing the membership interest or shareholder interest of a company, and the difference is a membership interest is a LLC. They're buying an LLC, limited liability company. A shareholder interest would be like a regular corporation. So for this purposes, they're used interchangeably. Membership interest, shareholder interest. When a buyer is buying a membership interest, they're buying that company, and that company will generally be sold with a lot more potential liability. What that means is all of the liability, which could be very clear or it could be completely hidden, is generally going to be sold with that company. Not only the liabilities, but of course the assets, its employees perhaps, its standard operating procedures, and its regulatory compliance issues, both good and bad. So the due diligence generally is always longer when it comes to the purchase of a membership interest. This is usually reflected in the purchase agreement. During the purchase agreement or the negotiation of the purchase agreement, we will generally negotiate the length and the scope of the due diligence process. With the more assets or the more holdings that the selling business has, the longer the necessity to perform due diligence, because there's more things to investigate, there's more things to discover. It is incredibly important that the buyer perform the required due diligence and the necessary due diligence. One reason is because courts, when determining whether, so for instance, in a situation where a seller is selling a business and doesn't disclose everything, even if they don't have to, sometimes there's things that just don't have to be disclosed, like perhaps things that they don't even know about, like perhaps environmental problems or non-compliance issues that haven't been discovered yet. it's necessary that the buyer go and do their own due diligence. Courts have always, or usually say that it's really upon the buyer to perform their own due diligence, and their inability to do so, or if they don't do so fully, is going to be on them. And so they really have, there's a lot of liability that can, or problems that can create if they don't perform the due diligence that's necessary. And that comes with the time. The time, if they don't have the time within which to do it, or that they're not immediately trying to do this due diligence immediately after the execution of the purchase agreement, I've seen it over and over again. It causes a problem, and it can cause a significant problem when you're buying a marijuana business. So, in general, the longer the due diligence period is longer when we're doing the purchase of a membership interest. Of course, one of the most important considerations when purchasing a business, a marijuana-related business, is the licenses. The licenses, both the municipal license and the state license, that make it a marijuana business. A marijuana business cannot be a marijuana business without at least in Michigan, cannot be a marijuana business without the municipal license, and of course without the state license. So it becomes necessary, and one of the most important things for the buyer is to investigate it. The buyer should never assume that that the license, for instance, is just there's no problem with it, because there could be a number of problems with it. For example, the renewal of the license is always important. It's one of the first things that I think about, and that renewal is generally an annual renewal. So the municipality will have an annual renewal date. The state will have an annual renewal date. I can tell you from my experience that the state, in renewing a license, generally takes between 60 and 90 days in order to accomplish. So if a seller is going to buy a marijuana-related business or a licensed business, and they haven't looked and seen when that renewal occurs, they could be late in enforcing that renewal and filing for that renewal. And by the time they actually buy the business, the license could be expired, and that could cause a significant problem. I've seen this before. It is something that is really important that the buyer ensures, because the seller doesn't necessarily have an obligation to say this is when the license renews. This is public information. This is I mean, unless it's in the purchase agreement that says the seller needs to disclose this, and this. Unless it's specifically enumerated, this is up to the buyer to decide or to determine these things, to investigate these things. So license renewals become really important. That same thing can be said for the municipal renewals, because again, there's going to be a renewal for the license for the municipality, there's going to be a renewal for the license for the state. Now, this also brings into a situation where the buyer has to determine whether there's any regulatory infractions or non-compliance. For instance, if the existing business had a record of, let's say, selling marijuana to minors, and they were perhaps the municipality was getting sick and tired of it and was thinking about revoking that license for some reason. A buyer looking to buy that, particularly the membership interest of this business and the license, are going to inherit those regulatory non-compliant issues. Perhaps the seller of a business is having problems with a particular diversion of marijuana. Maybe there's a problem with theft or dishonesty from some of the employees. There could be police reports that exist that illustrate problems with non-compliance. These are just a small number of things that a buyer is going to have to become aware of, or at least ensure that they exist or don't exist before they undertake the exercise of buying a license or buying a company that is a marijuana business. This is part of the due diligence. So again, the license and the nature of the license and the facts of the license need to be investigated. It's very important. It's particularly the renewal of the license and maybe even discussing that with the municipality. Another very big issue that needs to be performed as far as due diligence for the buyer are the taxes that relate to the business that is being sold. There are a number of taxes or tax liabilities that could be undertaken if not investigated or ensure that they're giving appropriate credit. Taxes could include the sales tax, the payroll tax withholding, or the excise tax, the marijuana at 10% excise tax on recreational marijuana. There could be personal property taxes. There could be income taxes by both the municipality and the federal government. These are all liabilities that could be undertaken and assumed by the buyer if they're not investigated. And these are things that it's just very important to look for taxes and tax liabilities from the buyer in part of their due diligence. It's also important to remember that the seller does have obligations to disclose. The seller will not be permitted to simply just keep their mouth shut. In fact, if the seller knows of a latent defect or a latent nonconformity, something that can't obviously be discovered, it is upon the seller to have an obligation to disclose it. For instance, I think I've seen situations where there has been regulatory non-compliance, and the MRA simply just hasn't discovered it yet, and the seller is likely hoping that it never gets discovered. But if they know that there's non-compliance, even if it hasn't been discovered, even if it may never be discovered, it is still incumbent upon them, the seller, to disclose this to the buyer. And they often never do because, again, they're hoping that it never gets discovered. But this can come back later and cause a significant problem for the buyer. For instance, and you have to remember, the MRA, they have records that go back for a long period of time. They can go back and look, let's say, metric records and the financial records and the recorded records. There's records that exist that the MRA can go back and identify non-compliance. And so the buyer really does have to perform the adequate due diligence in order to ensure that there's no regulatory non-compliance. If the seller does not disclose latent defects or latent regulatory non-compliance to the degree to which that the buyer couldn't have figured it out themselves, they could be found to have been in violation of the agreement. The agreement calls for the seller always is going to have the obligation to disclose material facts that perhaps the buyer wouldn't have known. That's at least should be in the purchase agreement. It's the lawyer's responsibility to ensure that the purchase agreement sets forth the obligations of the seller to provide the appropriate disclosures. That's a very standard and important term that needs to be determined or contained within the purchase agreement. Large due diligence projects, particularly when the selling company sometimes are often selling multiple properties, multiple facilities sometimes. Sometimes it's necessary to build a due diligence team. It is that important where the buyer will have to assemble a team, sometimes comprised of a financial auditor or a CPA. Sometimes it may include somebody from human resources to be able to judge and understand the circumstances with the employment group and human resources. Oftentimes a lawyer is involved in order to even lead the team because the lawyer is responsible for the legalities of the business and understanding its license issues, for instance. Environmental issues are often an issue as well, particularly when a buyer is purchasing land or that is part of the acquisition is land, and so sometimes it's necessary to hire somebody that's specifically related to environmental, or that the activities of the marijuana business, like for instance if it was a grow license, may be engaged in some type of environmental contamination or violations, and so we often hire environmental specialists. it's just necessary to have a team with certain types of transactions, larger types of transactions. A team is necessary to be assembled. And oftentimes, if I am leading a due diligence team, I am structuring all of these activities to ensure that they can occur within the due diligence time frame. We're given a due diligence time frame at the very beginning, and it's necessary we use all of that time in order to do the appropriate due diligence, the appropriate investigation to ensure that the buyer is buying what they are contracting for, what they believe that they are getting, and making sure that they are not undertaking any liabilities or undertaking any situations that they are not aware of. Again, due diligence is incredibly important in the buying and selling of a marijuana-related business, really of any business, but of marijuana-related businesses, there are very special considerations that have to be looked out for. The scope of the due diligence is important. You can find more and learn more about that at our website, cannabis-legalgroup.com, or feel free to reach out. We'd be happy to assist you in ensuring that the purchase of a business is going to be with the appropriate due diligence. Thank you for watching.